Good evening, everybody. It's been a long time. It's been a little over a month, so I'm a little behind. It's been a pretty busy time, but welcome once again. I appreciate everyone tuning in. So this is the fourth in my series of Social Security disability topics videos. As always, I have a slideshow that I'm going to present to everybody. That'll help explain what I'm going to be presenting tonight, especially again for those of you who are more visual like myself. So hopefully this will be a very useful one. All right, there's my screen share, and let me actually get the slideshow started so I don't give too much away. All right, so tonight's topic is definitely one of my most popular ones. I know it's definitely one that's going to be very useful for anybody who views it. And this is definitely something I spend probably more time with my clients doing than anything else. Without further ado, how to prepare for your ALJ hearing, the making of a Social Security claim. So I decided to have a little more fun with this one, other than changing the background. The other background was getting a little bland. But more importantly, I decided to theme this after movies as a general theme, because I see a lot of parallels for one thing, but also I happen to be a big movie buff. I like movie trivias. Definitely, if there was a game show about that, I'm sure I would excel pretty well. As my wife would say, she's very fond of saying, all she has to do is say something like, "What was that movie with that actor that played that role?" And literally that generic, I can come up with what she's thinking of. So I thought I'd have a little more fun with this one, but it also is a fairly serious topic. So I definitely want to cover some important ground. So this is going to be completely devoted to basically everything about the hearing level, which is the second stage of appeal, third level of a claim, period. But the second stage of appeal, as I've said in prior videos, many claims will get to this point, and this is usually the point where the majority of claims that are won are won. If your claim is going to get approved, it's much more likely to get approved at this level than any level before it. So I'm going to be doing what I do with my existing clients, which is hearing prep. This is basically exactly the same as what I do with my clients, but there's also going to be some other components that precede that, just talking about everything that happens from the time you request a hearing until the time that you actually do the hearing, and then a couple things thereafter as well. So without further ado, let's jump right into it. Once again, again, having a little fun here. This is my usual About Me page, but I branded myself documentarian here because that's kind of what I'm doing. I'm documenting the making of a Social Security claim hearing level. So there's all my information once again. Certainly, if you've watched any of my prior videos, it's all in there as well. Nothing different or earth-shattering. All right, administrative law judge hearings. Let me move this out of the way if possible. So try to give you more. There we go. A little bit more room to see everything. All right. So as I said, this is the level where the majority of successful claims are approved by experienced judges who are hired by Social Security to decide these claims fairly and impartially. Now, some of you may be viewing this video and see a statement like that and thinking pretty skeptically about it, because truth be told, hearings are becoming it's becoming a little bit more murky. I'm seeing a lot more uptick of what I consider unfair, unjust denials, like kind of haphazard decisions. There's a lot of theories behind it. You know, some would say that the people who are getting made judges don't really have the requisite amount of experience that they should. I know that a good majority of judges either have worked within the organization or have been existing practicing attorneys like myself. Unfortunately, that doesn't always amount to treating these claims fairly and reasonably. I've definitely seen my uptick of decisions that are just not only just off the charts ridiculous, but just seemingly have no basis in reality, which is why there's additional levels of appeal beyond them. But overall, I think the process is a fairly decent one. It's definitely could be worse. So that's what this stage is about. Now, As I said, there's a hearing at this level, but this is nothing like going to court for any kind of trial or court hearing, whether it's a jury trial, bench trial, whatever. These hearings are very informal. They're actually more informal than going to traffic court, if you've ever been to traffic court, and that's pretty informal. Usually these hearings are done by phone or online video from the comfort of your own home. The judges are very laid back and easygoing. There's no opposing attorney to cross-examine you or object, and there's no formal rules of evidence or procedure. You basically just talk to the judge to explain why you're disabled. And so I forgot to mention, what you're seeing on this particular slide is lifted from my original video that I posted, the very first one about the ABCs of Social Security disability, but we're going to get into a lot more details in the coming slides. So just a little bit of a refresher, but I'm just reiterating a lot of this. Again, this is a little bit of a summary, but you'll see that some of this stuff repeated on the subsequent slides. Formal written decision is sent in the mail with substantial details that the prior two levels of denial before this don't provide. Again, as I've stated before, if you don't have an attorney at this level, it is strongly advised that you retain one, because it can be very difficult to prevail before these ALJs without an experienced attorney. And again, if you don't have an attorney the first time your hearing's called, you can be granted an automatic postponement one time to get one. So definitely wouldn't even let it get to that point. If you don't have one by the time you've requested a hearing, now's the time for sure. All right. So things to know and do before the hearing with the ALJ, what I call the pre-production phase of the movie, getting everything in position. So the hearings are scheduled at least 75 days out unless you specifically waive that requirement. So when you get a notice that your hearing's been scheduled, it will be at least 75 days prior to that date. So it gives you ample time to, number one, if you don't have an attorney by then, certainly get one, but more importantly, get everything in line for it, which we're going to get to in just a moment. Now, again, phone hearings have really become the norm since the pandemic. You know, we were forced into that. Even though Social Security had the capabilities to do phone and just remote hearings in general, I had several experiences over the years before the pandemic was ever a thing, where I would actually call in if I was ill and didn't want to come and spread my germs in the hearing office. Likewise with my clients, if they were ill or just couldn't otherwise because of their medical conditions attend a hearing in person. Social Security has also done, and I'll talk about this in a subsequent slide, remote video hearings or video teleconferencing, which is a little bit different than this. It's not really a thing anymore, but you know, the bottom line is they've had the capabilities of doing this, and phone hearings tend to be the quickest scheduled ones over in-person hearings. Even though they have started offering them again, they take a lot longer because there's fewer judges available to do them, as well as staff in those hearing offices. So many people are still working remotely, and I think that's the wave of the future. Now, they do also have online video hearings using Microsoft Teams as the platform. And if you have a working internet connection, that's fine too. We're going to get into a little bit about both of those in just a couple minutes. So is one better than the other, meaning phone and online video versus in person? Well, actually, I'm just realizing for some reason my slide didn't come up with what it was supposed to. So I guess just to go back, the answer is it depends. Honestly, a lot of people ask me, is there any clear advantage to doing an in-person hearing where the judge is in the same room and can see you and observe you versus a phone or an online video hearing? And my gut reaction to that is always no. It absolutely makes no difference, because yes, there might be an argument to make that, particularly if you have something that really needs to be observed in person, it can make a difference. But the reality is the vast majority of judges that decide these claims are going to decide the claims on the basis of your medical evidence, the testimony you give, which they're listening to. They're not watching you as you give it, they're listening to it, and they might be listening back to the recording after the fact. And it's the rarest occasion where a judge might actually observe something that might make a difference in their mind. There's a story I could tell. I'm not going to get into it for the purpose of this, but there was a judge that came to speak at a seminar once before and gave us a story about how the ability to observe. This was back when in-person hearings were the norm, but where it made a difference. But overall, if you can tell it in words, which most people can, that's good enough. So it's not worth the hassle and aggravation, not to mention the inconvenience and the stress of trying to get to most of these hearing sites, to insist on doing one in person, plus the delay that brings about. So I always routinely tell my clients, phone or online video is the way to go. And phone even more so if you really want to have a convenience factor that you don't get even with online video, because no one can see you on the phone. And for some people, that's a huge plus, because it's so stressful, they don't want to be seen. They feel much more comfortable and at ease if they're just talking on the phone. And plus, nobody cares how you look if they can't see you. So, all right. Now coming to the current slide that's been sitting up here. Before the hearing is scheduled, planning for the release date of our little movie. So once you've requested a hearing, you'll start getting mailings from the hearing office, which is different than the field office where you get all your mailings prior to that. They'll send some confirmation letters just saying, we know you requested a hearing, we're going to be scheduling one soon. They're going to send some forms your way as well. This includes an updated authorization form 827, that's the medical authorization form, as well as an objection to VTC, that's the video teleconferencing we talked about before. That is a form you do not need to return unless you are doing an in-person hearing and doing it at the location where you may have the possibility of a judge not appearing in person, actually appearing before you on a video screen. It's basically a big TV screen where they can see you, you can see them, but you're just not in the same physical location. So if you want to do an in-person hearing and you want it to truly be that kind of hearing, like literally you're in the same room as the judge deciding it, then that's the only time you would return that form. Otherwise, it's one you can disregard. Oh, I guess I got a little ahead of myself here. So again, that little bullet point says what I just said. Now, there's other forms that may come before or after the hearing is scheduled. And these include a work background form, which is the exact same thing as the work history form you filled out twice before. You do not need to complete that one another time unless by some chance you've returned to work or you left something out of the work history and you need to update them. The other two forms, which speak for themselves, one is a medications form, which basically it asks you to tell them what your current medications are and various information about those medications. And then the final form is a recent medical treatment form, which is basically telling Social Security where you've been treating recently, so that if they need to request your updated records, particularly if you don't have an attorney and you can't do it yourself, they know where they're sending the requests. And that's also why you complete this 827 form. And by the way, I don't believe it's on any of my coming slides, but just one other thing to mention about the forms. Another form that will come your way, if you do want to do a phone or online video hearing, there is a consent form that you have to specifically send in that not only consents to it, but gives them either your phone number for a phone hearing or your email address to email the link for the online video hearing through Microsoft Teams. And that form is extremely important to make sure you send in as soon as you get it, so that they don't inadvertently schedule you for an in-person hearing where you may have wanted a phone hearing. Scheduling the hearing, or again, what I call the release date of our little film. Hearings are automatically scheduled, although some offices may call to clear a date and time with you. I've had offices that'll call me as the attorney to do that, even though they have my calendar of availability. But either way, once they are scheduled, those notices come out. And it'll have all the relevant information, including your assigned judge at that point. You don't have any control over who you get assigned to. And sadly, sometimes that can be half the battle. If you get assigned to a notoriously low approving, unjust judge, then that's what you're stuck with, but you know you have appeals options. If you have an attorney, they can access that information ahead of time to give it to you in advance. So, it's a little added bonus of having an attorney. Here are two resources you can use to look up judge approval rates and reviews of judges. So this first website here is actually Social Security's website. You can see it's ssa.gov. And this basically will tell you, you can look up the judge. There's a filtered search on there. As soon as you start typing a judge's name in, it'll filter it down to just that judge. And basically it'll tell you for the current year, how many total decisions they've issued, how many are approvals versus denials, how many are full approvals versus partial approvals. So it just gives you an idea of what their approval rate is. Now, many of them, you're not going to see huge rates. That doesn't mean that they're low approving judges, because the national average approval is somewhere in the 40% range, 40 to 50. If you see anything 50 and above, that's usually really, really good. And if you see something really high, that's kind of an outlier. If you see anything less than 30, that's usually a red flag that you've got a notoriously difficult judge. This site here is a private site. It's got a lot of ads all over it, but I think the information is somewhat accurate. This is the one I used to use in my early days. This is kind of like a Yelp site. It not only gives historical data on what the judge's approval ratings are, assuming the judge is still around, it also gives reviews that have been left by usually individual claimants. Occasionally you'll see an attorney having left an anonymous review too. But that might give you a little more insight if there's any up there as to how the judge might conduct their hearing. Now, they're not always, in fairness, that accurate. I've seen reviews for judges that I know are decent that really shred them apart, and vice versa. I've seen reviews for judges that I know are notoriously difficult or bad, and yet I suddenly see this person thinks they were phenomenal. So I don't know how much of it is legit or not, but just use that site with caution. But that's just another resource for you. Once the hearing is scheduled, now we're going to be going on our press tour to promote the movie that's coming up. So there's a little bit of to-dos before the hearing itself. And particularly once you have a hearing date, you're kind of setting your schedule of what's to come before the big day. So the most important task is to get your medical records as up to date as possible. And that includes, if you haven't already done it, getting any supplemental forms, reports, opinions, or letters from your doctors, including any of those special forms that I've mentioned in one of my prior videos, and I'll probably have a future video devoted to that as well. But that's the time to get them in. There is a rule that specifically states that all of your evidence that you're aware of, particularly medical evidence that is, has to be submitted no later than 5 business days prior to your hearing date. If you are aware of the existence of updated records and you don't submit them within that time, or you won't be able to, you are required under the rules to submit a letter to the judge, notifying the judge more than 5 business days before your hearing of the outstanding evidence and any attempts you've made to get that evidence, so that the judge is aware and can allow you potentially additional time after the hearing to keep the record open to supplement those additional records in. Now, if for whatever reason you're running into a brick wall and you just know you're not going to get the record yourself, another tool you have available is to request a subpoena from the judge. Different judges handle them differently. The rules and regulations technically say they're supposed to grant it when you request it, particularly if you've made various efforts to get the records and you're not getting anywhere with it. But every judge does it differently. As long as you notify them that they're out there and you think they're relevant and important, you've at least gone on record about that. And that makes a huge difference, because with those records not being in, if the decision doesn't go in your favor, that could be a technical ground for appeal by itself. And sometimes that could be worth its weight in gold. Okay. Sometimes it's appropriate, and in rare cases nowadays, it's even required by certain judges to file a pre-hearing brief to describe the relevant points of your claim and point to supporting evidence. My office, when I've done pre-hearing briefs, I really don't do them anymore unless a judge specifically requires me or asks me to. But basically, a pre-hearing brief, if nothing else, it lays out the 5-step sequential evaluation process information for them. So it lists everything from step 1 to step 5, and it makes reference to evidence in the record where I can make reference to it as to how I believe it supports the claim and proves that disability criteria and requirements are met. So it's not necessarily a bad thing to do, but one of the reasons against doing it is not really pointing things out, particularly if you have a judge that's notorious for denying claims. If you do that, then you could put yourself in a position where the judge is going to look at what you're arguing and find ways to combat it and get around it. So if you give them that heads up, you might be taking any potential appeal grounds away from you if they can really find a way to shore up a denial based on what you've argued. So, tread with caution on that one, I guess is what I would say. Also, another important thing to do before the hearing is to review the claim file either online, which generally the only way to do that is if you have an attorney that can access it. If you don't, they generally send you a disk, or sometimes they'll send it directly through email with an encrypted, secured email file that you have to enter a password in. But you need to review it, make sure everything's there that needs to be there. If there's anything that shouldn't be there or that you have an objection to, you'd have to note that in advance, and the notice of hearing instructs you on how to do that. Another thing too to be aware of is if you choose to, if you feel like you have strongly supportive evidence of disability, you can file what's known as an on the record or OTR request, which is very similar to a pre-hearing brief, but it's basically just pointing out and arguing why there's no other way this case can come out, that it has to be an approval. And if you file it ahead of time and you can flag it to the judge to let the judge know it's there, sometimes if you get a decent enough judge that has enough free time, they will pull it, look at your claim file ahead of time, and if they agree with you, they will actually agree to award you your benefits without having to do the hearing. And sometimes it comes down to the 11th hour where they look at it the day of or the day before, but it's still a better outcome than doing a hearing and leaving it up to chance. So really, you got to have truly pinpoint evidence, typically either meeting a listing at step 3 or perhaps one of the grid rules at step 5, which I'm going to get into more details on that in a couple of future videos as well. But it's just something to keep in mind. And, basically, before I get to the next point there, anyone who views my videos, if you ever want or need any of my forms or templates, I'm always happy to share them. Just send me a request by email or give me a call. All right, and finally, get prepared. How to prepare for a hearing with an administrative law judge. This is the red carpet interviews portion of the whole experience. So if you have an attorney, he or she will prepare you as the hearing approaches. But if you don't, you definitely come to the right place. Now, for me personally, I always prepare my clients for hearings the day before, or if it's a Monday, then I do it the Friday before, because I like it to be fresh in their minds. I don't want to do it too far in advance, but I don't want to do it too close to the hearing either. And over the years, I've found that the day before typically works perfectly. Now, my prep typically takes about 30 minutes or so by phone. Doesn't mean it only takes that long. Sometimes it's longer, particularly if it's more involved, or if you as the client have questions, I always take the time to answer them, make sure you're comfortable with everything. The goal is for you to be fully in the know and know exactly what's going to be coming for that hearing the next day so that you're not caught off guard. Now, before a phone hearing or an online video hearing. So day of the hearing has come, but it hasn't started yet. So this is what I refer to as picking out your outfit for the big red carpet premiere. For a phone hearing, you and your attorney will be called by the hearing office around the scheduled time of your hearing to get conferenced in on the secure line that's used to conduct the hearing. It is vital that when you fill out that consent form for the phone hearing, that you provide a good working phone number. And if it's a cell phone, you need to not only be in a quiet, private location free from noise and distraction, but you need to make sure you have good reception. That is crucial. If you don't have good reception, then the call may not come through clearly, and that's not going to make a clear recording of the hearing, and then that could cause technical issues that could throw the whole thing out and you have to do it again. So be mindful of that. For an online video hearing, you'll be clicking the link they provide you by email, which you should get in advance, and I think a reminder one either the week before or the day before. And You either click into it at the time of your scheduled hearing or before, just like any other type of virtual meeting platform. Social Security is the host. They'll let you in when they're ready. One interesting tidbit, and this has come up a couple of different times on hearings I've done. Online video hearings have a special live captioning feature available. I think if I'm not mistaken, all remote video, online video platforms have this, but Microsoft Teams specifically, because I had to research this. I've had a couple of online video hearings I've done recently were partly done out of necessity because my clients had significant hearing difficulties. They weren't fully deaf, because if they were, they would have qualified on that basis, but they had significant hearing difficulties among their other impairments, and they needed to be able to read the words on the screen in order to follow, which is not something you can do in person either. That's why online video sometimes is a really, really great option. So, get yourself familiar with the platform ahead of time if you're able to, if you're not already. Important facts about the hearing, the coming attractions before the main feature movie starts. Hearings are held privately. There's no audience of random strangers, and that includes live in-person hearings. They are held in closed, locked door private rooms. So this is not like a courthouse where you go into any random courtroom and you can just sit in the galley and watch. No, they do not allow random strangers to listen to your personal business, because it is just that, your personal business. You don't want anybody listening in. And obviously it's no different by phone or online video. Who would actually want to chime in on and join in to listen in on somebody else's phone call like that anyway? Now, there's up to 5 total people that generally participate in these hearings. First, of course, we have you as the claimant. You are the star of the show. Your attorney, your supporting cast. The judge, the director of the whole thing. The hearing reporter, the producer. This is the person who initiates the call or starts the online video hearing, and they also make an audio recording of the hearing for a future transcript if needed. He or she will be quiet, and if it's a phone hearing, they're going to go on mute once the hearing starts, so they won't come back on unless there's a technical issue that they need to help with. Finally, we have a vocational witness, sometimes referred to as a vocational expert in quotation marks. That's what I refer to as the crew and extras, and I'm going to get into what they do a little bit towards the end of this. Now, I said up to 5 total people participate generally. There can be more, and the more would be right here at the bottom. I didn't even label who they would be. They'd probably also be considered extras as well. So for outside witnesses, if you have a family member, friend, or a caseworker, or even a medical provider who's willing and able to provide testimony on your behalf, you can ask them to testify. Now, one thing to be aware of is that they will be asked to wait in another room until it's their turn, which is the exact same way it's typically done in court. They don't want outside witnesses listening to your testimony first, because it could guide or influence what they testified to, and they want their testimony to be independent, which is perfectly fair and logical. So it's not influenced in any way by yours. Now, generally speaking, judges in these hearings, because they are scheduled in specific time slots and they typically have a certain amount of time allotted, even though they're not supposed to be putting you on a time limit and pressuring you, but because your testimony could take a fair amount of time, which we'll get into in a moment, you'll understand why. A lot of times judges don't like to have a whole slate of outside witnesses, nor is it really even always necessary, which I'll get into in a minute as well. So typically 1, maybe in the rarest occasion 2 outside witnesses can sometimes be allowed, even though their testimony is typically going to be pretty brief. Now, another thing to mention too, and I didn't put it on the slide as I'm now realizing, but I'll say it out loud. Sometimes Social Security also calls an additional witness, specifically a medical expert. Now, when they do that, sometimes it's a good thing, sometimes it's not such a good thing. There are judges that bring in outside medical experts for the purpose of trying to see if they can approve your claim on the basis of what that medical expert has to say, if it's going to be favorable to you. And sometimes a medical expert will, in fact, come out and testify that you meet or equal a listing, or they'll give you such significant limitations in your residual functional capacity, that's going to qualify you for disability. But on the flip side, of course, I've seen many occasions where a medical expert comes in and just really tanks your case for you. And if it's clear the judge is going to rely strongly or solely on that medical expert's testimony, then all you can do is just try to quote, attack it where it needs to be attacked, which is, again, something I'll probably include in a future video session. But it is something that they are entitled to do, and you can't stop it if they're intending to do it. There might be limited circumstances you can offer objections to that testimony, but generally speaking, if it's going to happen, it's going to happen, and that will happen first if it happens at all. Okay, let's continue. Once the hearing starts, lights go down. So the judge is going to make some opening remarks to explain a bit about the hearing process. Usually those are directed to you as the claimant, because you're the one that's probably not as familiar as everyone else. So generally this includes statements saying something to the effect of, you requested a hearing because you disagree with the prior determinations that Social Security has made. I am not bound by those determinations. I'll make a new and independent decision, which will be based on the evidence and testimony provided here. And I will not be considering the prior denials, even though the reality is more often than not, judges that come into the case seeing that it's been denied twice will look at the reasoning behind it and see if they agree or disagree with it. So they kind of do and they kind of don't. Now, for phone and online video hearings, you'll also be asked specifically to verify that you're in a quiet, private location, again, free of noise and distraction, and also that you are not privately recording the hearing, which is a huge no-no for security and privacy reasons. So always just have to affirm that to the judge. Now, you and the vocational expert, and if there should be a medical expert that Social Security wants to testify, will be asked to take an oath, which is honestly the only formality of the hearing. As I've said before, the rest of the hearing is extremely informal and relaxed. It's very smooth flowing, conversational in nature. There's no rules of evidence or procedure, and they're not adversarial, meaning there's no attorney on the other side who's opposing you, doing cross-examination or objecting to anything. So these hearings are just really, like I said, just a very simple conversation between people, you and the judge and your attorney. If there is an outside witness that's going to testify, they get their oath taken when it's their turn to testify, since they're not in the room from the get-go. And you may be wondering, well, if the other witnesses have to wait out of the hearing, why does the vocational witness get to be a part of it? Because Social Security makes the rules, and sometimes they need to be there because there's certain testimony they have to hear for their purposes, which you'll understand when I get to it a little bit later. But their hearing of your testimony is not really anything that's going to impact what they do. So it's not anything to be concerned about. Now for your starring role. I'm ready for my close-up, Mr. DeMille. Here we go. So the bulk of the hearing from that point on is your testimony, probably about 90% of the hearing. So that's what the bulk of the rest of this presentation is about. So for phone and online video hearings, oh, I don't know why I repeated that line there. We took care of that already. And we took care of that. Again, not sure why that repeated. It was not supposed to repeat, but that's fine. Let's continue. And action. Here we go. So why are we there? What's the plot of this movie? To prove that you are disabled, that you're unable to work full-time consistent work due to your medical impairments and the resulting limitations. So every question that you get asked by the judge or by your attorney will go towards that ultimate question of disability. So the format of the testimony, like any kind of testimony under oath, is questions and answers. You have the answers, but who asks the questions? Well, that depends. In some cases, the judge will ask some or the bulk of questions. Some judges, if you're lucky enough, will really engage with you, meaning they'll listen to your answers carefully and they'll ask specific follow-up questions based on that they weren't necessarily planning to ask, but that your answers drove them to ask. Whereas other judges who ask any questions at all will just rigidly follow a, quote, script and they won't go off the script. They'll just be very mechanical and robotic about it, and that's more or less what they do. I typically have found historically over the years that the judges that engage with people more are usually the ones that are more fair and reasonable in their decisions. That doesn't mean they're automatically going to approve you, but it means they are going to give you a fair shake, and it means they're interested genuinely in what you have to say. So if you draw a judge like that, it's always a good thing. My ultimate hope at minimum is always that you at least get a judge with a good bedside manner, one that's not going to make you feel lower than low, like how dare you have the audacity to be filing for disability before you hit full retirement age. And God knows there are some judges out there like that really like grill you and put you on trial, like you have such nerve doing this. So hopefully none of you get to experience that. I certainly, as an attorney, have experienced it. It ain't pleasant, that's for sure. Now, some judges don't ask any questions at all, and they let the attorney ask them all. And I have mixed feelings about that. I mean, sometimes that's not always a bad thing, but other times it just means the judge really doesn't care. And in some really extreme cases, it's because the judge knows they're only doing the hearing because they're required to by law as part of due process. But sadly, those kind of judges more often than not already have their minds made up before they even come into the hearing room. It's terrible, but it does happen, and they get away with it more than not. Now, one important thing to be aware of is that no matter what, the attorney must always be given the final opportunity to ask questions. So if the judge is asking any questions at all, the attorney follows up after that. When the attorney's done, if the judge comes in after that and asks follow-up questions, the judge still has to turn it back to the attorney and say, do you have any follow-up questions based on that? And that is crucially important. And I always tell my clients this ahead of time, because I always tell them, I don't want you to worry or be caught up in giving too much detail or asking yourself, did I give enough detail? Did I get the answer, quote, right? Did I give as much information as I could have? Did I do the best job I could? Because that's more so your attorney's job to worry about than yours. And the attorney, if you're like me, among other things, during the hearing, I'm listening very intently to what you're saying, especially if I'm not the one asking the questions, and I'm taking copious notes on my computer, because if there's areas I look at and I say, yeah, we better go back to this and follow up on it or flesh it out more, or just, dive into the details, then that's what I'm going to be prepared to do, in addition to whatever other questions I have to ask that the judge didn't cover. So if you have an attorney, your attorney should be on top of that, hopefully. So that's why it's such a crucial component of these hearings, is the ability for the attorney to have the final say. And that goes with all witnesses, not just you. And action. So what are the questions? What's building up to this plot of the movie here? Well, there's two main categories of questions that you're going to get asked. Every question falls into one of these two categories. The first category is what I refer to as background and confirmation questions. This is basically exactly what it sounds like. It's either confirming information in the file or it's getting background information. This includes such topics as general background information, name, address, date of birth, marital status, children under 18, etc. Your education and your work history over the last 15 years, aka your past relevant work, like we've talked about in the prior videos. And that, by the way, is the area where the vocational witness is going to be most relevant to, as far as listening in to what you have to say, because that's going to be relevant to the testimony they give, potentially. Questions about your medical conditions and impairments that you've been diagnosed with to date, the treatment you've received for those impairments, medications and side effects, and things of that nature. So all very simple, straightforward stuff. Now, the second category of questions, which is by far the more important of the two, are questions concerning your symptoms and limitations. And the reason I emphasize that the way I did is because that makes or breaks your case. So much so that it's going to get its own slide. And let me avoid the suspense. No cliffhangers here, but the climax. This is the climax. This is what I often consider the climax of the hearing, because again, this is what makes or breaks your case. How do your impairments individually affect you on a daily basis? That's what determines whether you can consistently do full-time work on a daily basis or not, and AKA whether or not you're disabled. Because many people have the same diagnosis on paper. That doesn't mean they experience it the same way. So you have to be prepared. And this is no different than when I talked about in my prior video about the function report. This is basically the function report coming to life. This is you bringing your claim off the paper. And if you don't tell the judge everything that needs to be said, the judge won't necessarily be prepared to read between the lines any more than DDS is prepared when they read your function report. That's why you've got to get everything out there possible. And this section of the hearing and the testimony, these topics are the most crucial ones. Now, there's two types of symptoms and limitations when we're talking about symptoms and limitations. First ones, of course, is what you typically think of when you hear the word symptoms and limitations, physical or exertional. So this includes things such as how long you can sit, stand, or walk at one time, and whether you have to stand or walk in a certain orientation, whether you have to sit in a certain orientation, like with your legs elevated or reclining. How much weight you can lift or carry comfortably, whether you have a formal weightlifting restriction from your doctor or not, or whether you just know what you can or can't do. How well you can do various postural movements. Here's examples of them: climbing, bending, kneeling, etc. And this includes both your upper extremities and your lower extremities, all the way down to the hands and fingers. Whether you need to use assistive devices to walk or stand, like a cane, walker, wheelchair, crutches, anything like that. Physical activities around and outside your home, taking care of your own personal care needs, like bathing, getting dressed, using the bathroom, household chores like cooking, cleaning, laundry, going to doctor's appointments, grocery store and shopping, driving, things like that. All very simple, straightforward stuff and very important. Then the second type of limitation we have, climax continued, are what we call the non-exertional limitations. And this is actually the more important one of symptoms and limitations. The reason I say that is because these are the types of limitations that are much harder, if not impossible, for an employer to accommodate. And if that's the case, that pretty much is going to lead to you not being able to work for an employer and therefore meeting the criteria for disability just the same. So these include things such as maintaining attention, concentration, and focus. This is huge. And this is huge because, number one, despite what some judges and decision makers would have you believe, attention, concentration, and focus issues don't just stem from people that have mental health impairments. Certainly that's a component of it, but that is not the only kind of impairment that can wreck your attention and focus. If you have a physical impairment that causes pain, which is obviously a humongous symptom, causes numbness, causes tingling, causes weakness in the muscles, causes fatigue where you feel like you need to rest constantly, causes any kind of other type of limitation. You have a bathroom related impairment, digestive disorder or urinary disorder, and you're going to the bathroom all the time and you're focused on that when you get urges to go. If you have some kind of stomach problem where you're constantly focused on nausea. I mean, I could go on and on about this, but the bottom line is almost any type of impairment can cause some level of difficulty with maintaining attention, concentration, and focus. And you have to describe that in much detail as you can, particularly where it affects you on a daily basis. I mean, many of my clients would tell you they can't even sit down and watch a TV show, not a movie, no pun intended. They can't even watch a half an hour TV show, news program, whatever, because they're constantly focused on pain. They're falling asleep because they're always exhausted and fatigued. Like I said, these are the kind of details that you cannot hold back on because the judge needs to hear them, even though they're going to look for evidence of it in your medical records, even though that's not the most accurate gauge of it, which is another story for another day. But your testimony still needs to get in the record of saying where you're limited in these areas. related to that, being productive and staying on task to complete things timely or at all. If you recall on the function report, there is a box on there and a section asking about whether you finish what you start and whether you can complete tasks. So again, in order to be employable, you have to be able to be productive and stay on task in the workforce. And we'll talk more specifically about that in a later slide here. Your short and long-term memory. Are you going to remember what you need to be doing? You're going to remember how to do it. You're going to need to be told over and over again or reread instructions. Handling stress. Obviously, certain kinds of work offer more kinds of work-related stress, changes in the workplace, decision-making, and those are important to be aware of. If you do, this is usually much more so in the mental health side, but it again can come up in the physical health side also. Are you able to be around, interact, and get along with others outside of your home well and consistently, or do you tend to isolate? Particularly on the mental health side, if you have panic attacks or anxiety or depression or things of that nature, being around other people might be difficult. And there aren't many jobs that don't require at least some level of that. So that's important too. Finally, staying motivated without the need for support, encouragement, or in some cases, reminders to do even the simplest things like taking your medications daily. If you're not somebody that's like an early to bed, early to rise kind of individual, and you constantly need somebody to be on top of you to do this and that, if it's going to be the same thing in a work environment, that's not going to be employable. And if you have some kind of specific situation that you would require the equivalent of an accommodation, then obviously that's important to note too, because certain kinds of accommodations under the Americans with Disabilities Act also negate competitive employment, because competitive employment means employment that you don't need reasonable accommodations for. One specific example that's come up a few times in recent hearings for me, and there's actually some case law about it, is if you have officially a service animal. Now, the ground is a little bit more murky and a little bit more gray area if it's an emotional support animal, even though they do some of the same functions as service animals. But a true, honest to goodness service dog, whether it's somebody that's there, if they're there helping a blind individual, then usually the individual is already disabled on the basis of blindness. But if they're helping somebody who has anxiety or panic attacks or PTSD kind of things and helps calm them down officially, that's the same concept. So make sure you're making the judge aware of these things as well. Being punctual or consistently attending to things, or specifically attending work if you're not going to be regularly absent, whether it's because you're having bad days or you have to go to the doctor regularly. So the bottom line is, the more you have these things, and if your medical records support them, it's really hard for a judge to deny your claim and get away with it. So when you have these kinds of limitations, make sure you speak up about them and put as much detail behind them as you can, because that can really be the difference again between an approval and a denial. The pending resolution of the action section of the movie. So here we go again. Outside witnesses. We've mentioned a little bit about this already. So generally, the only reason to have your own outside witness is if you can't speak well on your own behalf. Oftentimes children fit that category if it's a childhood SSI claim and the parent speaking on behalf of the child. Sometimes you do have an adult that's got significant kinds of limitations from their impairments, mental or physical health, and sometimes they do need someone to speak up on their behalf, and that's fine too. But also sometimes if you have an outside witness, family member, friend, whoever, or a caseworker that has an outside unique perspective from their own knowledge and observation, and that can help bolster your claim. Now, you have to be careful because, again, since these outside witnesses can't be in the same room when you testify, they don't know what you said, and they may inadvertently testify in a way that contradicts what you said. So clear preparation is definitely a huge key. So when I know I've got a client that's got a family member, a friend, or whoever that's going to be testifying, when I'm doing the prep call, I'm making sure both of them are on the call at the same time to hear what I have to say, so that they know what they have to avoid doing to inadvertently contradict what the claimant themselves is going to be testifying to first. I'll never forget many years ago in an in-person hearing I had, on the day of the hearing, my client arrives with a friend, to testify on her behalf. I was much younger and a little bit less experienced, so I didn't think much of it. And it kind of goes against the grain of what we normally are taught as attorneys, because usually you want to include as many corroborating witnesses as you can in a typical legal matter. Not so much in these types of cases. It can oftentimes do more harm than good. And I'll never forget that this witness came in after my client testified and basically completely threw her under the bus without realizing she did it, because she testified that my client had actually been working for her for years, doing like more or less the equivalent of daycare for her child, where my client's telling the judge she's disabled and can't work. I wanted to crawl under the table and completely hide away. I was so mortified. And of course, we lost that claim. And that was a big lesson learned. And it was partly on me not knowing what this witness was going to testify to. I don't honestly think the claim would have been won anyway, but that's just a good example of how sometimes this kind of situation can come back to bite you if you're not careful. And their testimony, for that same reason, their testimony should always be brief. You do not want them going into a lot of detail. So the focus should always be what problems and limitations the claimant has from their own observation. It should be a little bit open-ended and allow the witness to elaborate in their own words without guiding them. You certainly don't want to be leading them through it, even though, again, without formal rules of evidence and procedure, leading questions don't mean the same thing in this kind of matter as they do in a typical court matter. But you probably get the idea. Questioning may be done by the judge, but generally they will let the attorney do the questioning. The judge might chime in with a question in the middle or towards the end, but usually they want the attorney to handle it. And they usually want it to be very, very brief. They don't want it to be, anything that's going to take a long time. The final act of the movie, the vocational witness. Now, as I said earlier on, the vocational person usually is referred to as an expert, quote unquote. Now, that term has kind of been floated around in a way that is let's say it's a little bit up in the air. And it's a very hot button debatable topic, because a lot of what these people testify to, it's fairly clear that they're not quite the experts that Social Security would have you believe they are. It's not to say they're not knowledgeable and experienced. They're certainly very educated. Most of them have masters or higher degrees. Some have PhDs. But again, their knowledge, and that's why I put knowledgeable here in quotation marks, because it's questionable at best what they're really knowledgeable about and how well they know what they claim to know. So typically what they're there to testify about and what they're supposed to be bringing their knowledge to is all the different jobs currently in the economy, according to the Dictionary of Occupational Titles, the DOT, that's the publication Social Security relies on, including the physical demands or the RFC of a job, the skill levels of the job, which I'll talk about in a minute, and what employers will or will not tolerate as far as accommodations, time off task, and absenteeism from jobs. Now, this person is not an employee of Social Security. They are an independent, neutral, and impartial contractor. They get paid regardless of the outcomes. They have no stake in it. They get paid whether you win or lose, even though at times it may seem like they are there to oppose you, and some of the testimony they give seems like it's very much against you. But many also testify regularly, so they're very well versed in this. We see a lot of the same vocational people over and over again. The judge will ask the questions, and if necessary and appropriate, you or your attorney, if you have one, can cross-examine them, which isn't quite cross-examination in the sense you normally think of it in typical court proceedings, but that's what they refer to it as. And all these vocational people also provide their resume, which becomes part of the file. So we have an opportunity to see exactly what experience they have before they testify, to see if it's really relevant enough. And if we think they're really not qualified, we can object to them. We can either object to their qualifications or object to their testimony during the hearing or after the hearing in some cases as well. Their testimony is pretty quick and robotic sounding. Like I said, a lot of them testify over and over again. The ALJs use the same questions, and therefore the vocational people offer the same testimony over and over again. Usually this testimony takes no more than 5 to 10 minutes tops. Final Act Part 2, the sequel. So their testimony covers two areas. First, they're asked to classify your past relevant work, if you have any, first by the skill level, or what we refer to as the specific vocational prep time, or SVP, which is basically, it's a number between 1 and 9. The lower the number, the less skilled or unskilled a job is, and also dictates typically how long it takes to learn that kind of job. So the more skilled a job is, the higher the SVP is, and the longer it's going to take to learn it. And then they also classify the past relevant work by the RFC level, meaning sedentary, light, medium, heavy, or very heavy. So that's usually pretty simple and straightforward. And usually they can do that before you even testify, because they've seen your work history and they know what you've done. Now, the second part of what they do, and this is the more involved part, they answer hypothetical questions by the ALJ, and then in some instances by the attorney. So they're not there being asked, you've heard so-and-so claimant testify. Do you think they're capable of working? And if so, what can they do? They would never put you on the spot like that. The rules and regulations don't allow them to, because you don't know this person from the next person and vice versa. So you wouldn't want some random Joe Schmo stranger that you've never met, had any dealings with, telling you your business. So instead, the way they do it is this. The judge will ask one or more hypothetical questions that sound something like this. Assume a hypothetical individual of the claimant's same age, education, and work history, and assume they have the following limitations. So first, they'll say, assume this individual can perform work at the, let's say, the light exertional level. That's a very popular one they love to start at. But this individual is further limited in that they blah, blah, blah. You know, they might say they can't lift more than 20 pounds. They can only stand and walk 4 hours of an 8-hour day, which is not typically what light work involves. They can only occasionally reach overhead, and I can go on and on and on, but you get the idea. And the limitations they give will apply to you, but they may not include everyone that applies to you. Once they go through all that, they ask, could this hypothetical individual perform any of the claimant's past work? If the vocational expert says yes, then they're usually not going to go further than that. But if they say no, they'll say, are there any other jobs available in the economy that this individual could do in significant enough numbers? And if so, the vocational witness gives up to 3 representative job title examples from the DOT. They'll give the job title, the DOT number that corresponds to it, and they'll say what the skill level of the job is, the SVP number, and the RFC as well. And they'll state also how many of those jobs exist in the local or national economy in significant numbers. And then that's what they'll do. And that also has become a major bone of contention these days. Not only the jobs that they're listing, because some of them are really questionable as to whether those jobs actually still exist, even if they are still in the DOT, but it's also become questionable whether or not the numbers that they're citing for these jobs and the sources they're getting those numbers from are reliable. And there's also debate about whether or not a certain number of jobs constitutes a significant number, because just as a reminder to everybody, at step 5 of the sequential evaluation process, Social Security has the burden to prove that there's work you can do in significant numbers if you can't do your past work. And if they can't prove that the numbers are significant enough, then that means they haven't met their burden. Therefore, you meet the criteria for disability. So it's so vital to make sure you take down what this testimony is. And it, you know, obviously the average claimant isn't expected to be prepared to know all this, but an attorney usually has enough knowledge that they can sometimes challenge it on the spot. Sometimes they have to challenge it after the fact, but some of the questions they may ask on cross-examination might speak to that. Now, cross-examination from an attorney typically covers different hypotheticals with additional limitations that more so match you as the claimant. But the goal is to get the vocational expert on record to say that there would be no available work that the hypothetical individual could do with those limitations, which is akin to saying the same thing about you. So one of the most popular questions that we will ask if the judge doesn't is if the hypothetical individual is going to be significantly off task or absent from a job on an unpredictable or unscheduled basis excessively. Usually the norm that a vocational expert will say basically qualifies somebody for being disabled or unemployable is if they're going to be off task 10% or more of the workday, and or they're going to be absent more than 1 day a month. Sometimes even just 1 day a month is enough. So those kind of limitations by themselves would be work preclusive. After the hearing, the box office result, how well did your film gross? Well, no decision is made on the spot with these claims, unlike going to regular court where a judge often will make a decision right there from the bench, or you'll wait for a jury to deliberate and get your decision. You have to wait a bit longer. You have to wait for the grosses to come in. So the decision comes out in writing after the hearing. Now, this is information that when I prepare my clients individually, I don't discuss with them until the day of the hearing when the hearing is done, because I like their focus to be on the hearing itself and not what happens after the hearing. But obviously, in this kind of form, it's a little different, so I'm covering it all at once. So the average wait time after the hearing is usually 30 to 60 days. It could vary. Sometimes it's shorter, sometimes it's longer. One thing that can hold a hearing up, or hold a decision up rather, is if there's something to do post-hearing, particularly if there's medical records that need to still come in, like we talked about earlier, if you're asking the judge to subpoena them, or if you're still asking for additional time to get them yourself because the provider's backed up. Sometimes they might hold the record open for anywhere from 1 to 2 weeks after the hearing, sometimes 30 days or more. Sometimes they'll say, if you need more time, ask us and we'll give it to you. But if the record's held open, that will halt the decision-making process. So once the record is officially closed, that's where the 30 to 60-day time frame comes in. Now, even though the decision comes in writing in the mail, and you and your attorney will get a copy, if you have an attorney, the attorney can access it online ahead of time. And while they're waiting for it, they can see the status and the progress of the where the claim is in terms of the decision process. So the 4 stages it goes through, or up to 4 stages, I should say, are either post-hearing review after the hearing. If the record's closed, they're reviewing it to make the decision. If it says post-hearing development, again, that means something more needs to be done. Usually it's outstanding medical records that we're waiting for. Sometimes they even hold the record to send you to see one of their doctors again for a consultative examination. Once the decision is made, the status changes to say pending decision writing, which means it's waiting to be written up, because there's a different team of decision writers that write these decisions for the judges. Then when it's in decision writing, it's being written up, goes to the judge for final review and signature, and then it says case closed. And at that point, the decision's in the file. The attorney can access it online, download it, and then wait for the official copy in the mail, even though they're one and the same. But obviously the attorney knows about it ahead of time. They can call you to either congratulate you ahead of time if it's coming your way, or cushion the blow if not. Now, if it's a fully favorable decision, that means your movie's a smash. That's a complete approval. That means you're going to be in Oscar contention later in the year. Sorry, can't let go of this movie obsession of mine. But congratulations if that happens. You're going to be getting your full benefits, and you'll be getting a notice of award letter in the mail. I think I've talked about that a little bit in the past, and that'll detail everything you need to know about the amounts, timing of it, so on and so forth. If you get a partially favorable decision, that's a partial approval. Still say congratulations generally, because you will get at least some benefits and you'll get ongoing monthly benefits. A partially favorable decision means they found you disabled, but as of a later date than what you alleged. So if you said you became disabled January 1st, 2000, they say, well, you became disabled January 1st, 2001 instead. That's a partially favorable decision. And that could impact the amount of retroactive lump sum past due benefits you get, but that's really all it would impact. So that's all that means. If it's the dreaded unfavorable, that means your movie was a flop and your claim got denied, and then you have to look to appeal to the next level, which is the appeals council, which is another video we'll do in the future, of course, but hopefully that's not what you ultimately face. So I always open it up at the end of the whole thing to questions, as always. Again, phone and email are the best ways to contact me, and I respond directly, as I've said before. the basic thing to be aware of is preparation is the key. The more prepared you are, the better you're going to do in your hearing, plain and simple. And it's no different than anything else in life. I mean, if you go into it haphazardly and you really haven't prepared, it's usually going to flop. You know, making movies takes a lot of time and energy. It takes a lot of different key players that play different roles. But at the end of the day, everyone comes together like a well-oiled machine, and that's what makes the difference between a true flop and a true hit. So hopefully your experience is a good one. You know, while there's never a crystal ball to know if you're definitely going to get approved or not, at the end of the day, the hope is that you will. And if you do, then that's great. And if you don't, you always have appeals options. But if you get denied, despite your best efforts to be as prepared as you can be, usually there's going to be, if the evidence supports it, at least there's going to be significant grounds to appeal, and you may have just gotten a bad break with the judge you got assigned to, or whatever the circumstances. But at the end of the day, preparation and knowing what's coming and knowing what you need to tell the judge, since they won't read between the lines, is key. And if you answer every question to the best of your knowledge and ability, you're typically not going to go wrong. So I hope you've enjoyed this presentation. I'll be looking for my next one sometime within the next month. And I hope you all enjoy the I guess official start to the holiday season. Thanksgiving will be coming up in a couple of weeks. So God bless to everyone, and I will look forward to talking to you soon. Thanks.